It's a lot of fun. And we're back. Thanks for bearing with that quick break, folks. So, Damian, back to you, doing sort of a regular walkthrough so we can dive into the language a little bit, but I appreciate you giving us that big picture.
Sure.
And I'm hoping we will finish, but I can't imagine that that's true. So let's just do what we need to do to understand the bill.
Sure. So I'm going to pick up with the special fund language. This is where we left off with the in-depth dive in. So
Could you say what page, please?
we are on page 15, line 13. So it establishes the program and the division. And then on line 17, we establish the Family and Medical Leave Insurance Special Fund. So there are a few minor tweaks to the language here that I'll bring back that Emily Byrne from JFO highlighted when she did a review the other day. But basically the fund can be expended for the administration of the program, the payment of benefits, and for necessary costs of administering the fund. And then interest earned on the fund balances shall be credited to the fund. Typically, we don't include that language, but because this is expected to be carrying a large balance with the reserve, the costs of the bookkeeping costs related to keeping those interest with the fund is going to be outweighed by the amount of interest you earn. So on smaller funds where you might only have $30,000 in it, it doesn't make sense. But when you're talking millions of dollars in the fund, that should be okay. It consists of contributions collected pursuant to the chapter, amounts recovered or collected pursuant to the two sections governing recovery of overpaid benefits and penalties, and then any amounts appropriated to the fund. And then it permits the director to seek and accept grants from any source, public or private, to be dedicated for deposit into the fund. That is boilerplate language, except we've taken out the word gifts, donations before grants. So it normally says gifts, donations, or grants. And the general committee felt that gifts and donations didn't really make as much sense as grants, where you could get a grant from the U.S. Department of Labor or the Gates Foundation or something like that related to programs of this sort, versus a gift or a bequest or something like that, where it just didn't feel like the right thing for this program.
And if in some future universe, the federal government decides to take this on, I imagine that federal money could go through that process.
Potentially, we'd probably have a lot of changes to make. But yeah, we could potentially, my guess is if the federal government did something similar to unemployment, we'd have to set up a separate trust fund, not a special fund, and go through a whole bunch of federal requirements to get the program up to standards, but you could evolve this into something that would comply with the federal requirements. So contributions, as I mentioned, this language in A needs to be changed. Currently, it sets the default at 0.55%. That's likely to change depending on how you adjust the program. The other thing is because we are having the division set the contribution rate annually, we don't want to have a statutory rate. You should set the initial rate in session law and then let the division update it. So the language in B governs deductions and withholding by the employer. So an employer may deduct and withhold up to 1/2 of the contribution required for each employee from the employee's covered wages and shall remit the full amount required for each employee to the Department of Taxes. And then in C, covered wages means all wages paid to an employee up to an amount equal to 2 times the maximum Social Security contribution and benefit base. So One edit there is to remove the word maximum because it is just the Social Security contribution and benefit base. And that is currently about $160,000. So the 2 times that is $320,000. That covers nearly all wages earned in Vermont. There are very few people who earn about that amount and would have exempt wages.
17.
And then self-employed individuals, again, the initial rate needs to be moved out of statute and into session law. And then covered work income means self-employment work income earned by a self-employed individual in Vermont up to an amount equal to 2 times the Social Security contribution and benefit base. Again, the word maximum needs to be taken out. You may want to discuss this language further with the tax department about whether it's precise enough. The goal is to focus on self-employed individuals earning money in Vermont and to prevent someone, say, who's self-employed in Arizona from enrolling in this program. Because you want it, it's based off of Vermont taxes paid. The language in B here requires that the director to establish the rate for the coming year on or before each October 1st. The rate is to be set so it generates contributions in an amount equal to the sum of the projected amount necessary to provide benefits, the projected administrative costs, and a projected reserve equal, or a reserve equal to 9 months of projected benefits, minus any balance that's in the fund from the prior year. So if you've been setting your reserve accurately, most years it should just be the cost of projected benefits and administrative costs because you'll already have that reserve. The rate of contribution has to be the same for the covered wages of employees and the covered work income of enrolled self-employed individuals and is not permitted to exceed 1%. So because the General Assembly would not be involved in the annual changes to that rate, the General Committee felt it was important to have a cap that would prevent the rates from just rising uncontrollably. And then number 3 requires the director, if the rate of contribution gets set to 1% any year, the director is required within 14 days after making that determination to submit a written report to the Joint Fiscal Committee, the Appropriations Committee, the General Committee, this committee, and your Senate counterparts. That provides a detailed explanation of the reason for the increase, whether the rate is sufficient to pay the projected benefits and administrative costs while maintaining the required reserve, an explanation of the solvency of the fund, and recommended legislative action to reduce the rate of contribution in the following year. So the idea being here that if the legislature has set a ceiling of 1%, your goal is to stay below that ceiling. And so they're bringing a recommendation for what it would take to drop that rate. Ultimately, the policy decisions about whether to raise the rate, make the changes to drop the rate or whatnot are all up to the General Assembly. So they're just bringing recommended action for what it would take. Questions on that? Okay. Commissioner of Taxes collects contributions required and deposits them into the fund. Employers shall withhold contributions as if the contributions were Vermont income tax subject to withholding.
And you don't have to read word for word. You could just tell us what the paragraph's about and we can read on there.
Sure.
That's okay.
So basically what this paragraph does is it sets them up the same way as income tax withholding, subject to the same enforcement provisions. So if an employer doesn't withhold income tax, the tax department has the ability to go after it or withhold the contributions, excuse me. The language in B provides that employers are responsible for the full amount of any unpaid contributions. This is so that an employee whose employer wasn't making the payments doesn't suddenly get a notice in the mail from the Department of Taxes saying you owe us 2 years of contributions because your employer didn't pay.
1 second.
Can you just explain what would happen in that situation?
They go after the employer. The Department of Taxes would go after the employer for the unpaid contributions.
And would the employee be provided the benefits that they were owed while that sought to?
That is the idea. You may want to just clarify that in the language. So it's not explicit. It does, the look back is at your income, not the amount of contributions withheld. So if you have the documented income, you should be entitled to the benefits, but you could add a brief sentence saying an employer's failure to pay contributions shall not affect an employee's eligibility.
If you think that's not explicit enough, Damien, please clarify that, because I think that's certainly needed to.
Making a quick note. Self-employed individuals, it is subject to the same requirements as estimated payments are currently subject to for a self-employed individual. Same enforcement provisions. And then employers with approved private plans are not required to withhold or pay contributions. So benefits, as I mentioned before, 12 weeks in a 12-month period. So 12-month period is basically, it's a rolling 12-month look back. So if you look back 12 months and you only took 6 weeks of benefits in the last 12 months, you've got 6 weeks of benefits to use. If during that 6 weeks, some of those weeks of benefits you used start to fall outside that 12-month look back, they get added on. So just the example is if you use 6 weeks starting January 1 and you needed to leave the next January 1, you would have 6 weeks of leave available to you. But when you got to February 14th, you'd have another 6 weeks of leave available for the coming 12-month period. Does that make sense to everyone? Okay. And then up to 2 out of 12 weeks for bereavement. 100% of average weekly earnings. As I mentioned earlier, average weekly earnings are currently defined as your 2 highest earning quarters in the last 4 completed calendar quarters, and then dividing those by 26. So that may change depending on how you do income eligibility, but that's based off of the unemployment insurance law. It's a very simplified version of what's in that law. And it caps out at the state average weekly wage, which is determined pursuant to the unemployment insurance law and is used for workers' comp and would also be used for this. So it's a calculation we're doing every single year, and it provides sort of a standard cap that goes up with wages in the state.
Representative?
Can for that section B, can you just explain how that would work for a self-employed individual?
So self-employed individuals are subject to that same cap. And so the best way to think about this is, so unemployment insurance covers a specific universe of employees. It is not all employees in the state. And what it does, how they calculate that wage is they take all of the reported wages for covered employees, and then they divide that out to get to an average weekly wage for those covered employees. That's then applied to workers' comp, which covers a different universe of employees, and it would be applied to here, which covers a broader universe of employees and also self-employed individuals. So even if the average wage for self-employed individuals was higher or lower, this is the cap that they've decided to use, in part because it's a number that we have and it's easily available.
And the 100% of an individual's average weekly earning would be to look back at the self-employed.
For self-employed, you look back at the 2 highest earning quarters of the last 4. So you have to document quarterly income in order to do that under the current structure.
You're looking at tax returns or estimated.
Yeah, well, so when you do your estimated payments, you're not providing quarterly documentation. Self-employed individuals would really have to provide quarterly documentation as part of being enrolled in the program.
And is that going to be figured out in rulemaking, like what the documentation would be exactly?
Right now, it's left up to rulemaking, how that would be done. But it's similar to what was ultimately required under the pandemic unemployment assistance, which again, I'm sorry for referencing a program that was problematic.
Yeah, referencing some terrible programs that give me so many feelings.
But the idea was basically that ultimately you would have to provide some documentation of income there. The problem arose in that because of the pandemic, the department didn't require a lot of that documentation up front and then had to go back to ask people to provide that, which was challenging.
And as we explore this with JFO and tax, there's an option to say maybe it should just be a look back at someone's total tax return from last year, for instance, and what the average weekly wage would be from that.
Yeah.
But that then means that you're looking at last year's income instead of this year's income. So like that is sort of something that's on the table for us to.
Yeah.
Just one last clarifying, are we talking about net or gross?
So we are talking about, I believe it is gross covered work income. Let's just see. Okay. Means self-employment work income earned by an enrolled self-employed individual up to an amount. So I think the interpretation here is gross, but it's actually not specific. So you could get more specific. Yes. Yeah, you could get more specific about this. And like the chair mentioned, one of the options would be to allow people who have prior year tax returns to just use that to determine their average wage, and then use the documentation of 2 quarters as a backup for people who are newly qualified or newly working in Vermont.
We do that for CCFAP and other assistance programs.
If you could just note that that's something that needs more specificity.
Mm-hmm. So, okay. You can receive intermittent leave benefits, so leave for a portion of a week. It's broken down into 1-day increments. So in the event that you have, for example, treatment that requires only 2 hours out of your day, you have the choice of basically taking a full day of leave and benefits for that, or working and taking sick leave for those 2 hours. So that's an option, but the program limits it to 1 day for administrative simplicity. Benefits are wage replacement for the unpaid leave laws. They importantly, this is a question that comes up, is they don't extend the job protected leave. This is just wage replacement that you can use during your job protected leave. These don't change it. So the situation I hear most often is if I take 12 weeks of paid leave benefits, and then at the end of my leave, I take 2 weeks of vacation, can my employer fire me? The answer is yes.
During that vacation.
Yeah, or more likely your employer can say you're not allowed to take vacation. If you want to take that time off, I'm not approving the vacation, so it's up to you. Employers are only required to get out to 12 weeks of job protection. After that, it's between the employee and their employer, whether they're protected. After that, some employers may say, take all the time you need. Other employers may say, I need you back on 12 weeks plus 1 day. So, and that's an employer's call. So.
And just want to make sure I said, that doesn't affect like a regular scheduled vacation at a time not related to the 12 weeks?
No, it doesn't. So your vacation time is so an employee's vacation time is between them and their employer. So if they've been scheduled and approved and so forth, the conversation might be, can I still take my vacation at the end of the 12 weeks? Or the employer might just say, and you've got your 2 weeks vacation after that. We'll see you after 14 weeks.
But
So it's entirely between the employee and the employer once you get outside the 12 weeks of job protected.
And separate from this bill, an employer can fire an employee for taking vacation anytime, ever, even if they're guaranteed, because we live this is an at-will state.
State. So
Even if it's in your contract that you can take vacations, you can still get fired for taking a vacation, right?
it gets a lot more complicated,
Yes.
but the bottom line is an employer can fire you for any reason at any time in Vermont, provided it's not against public policy. So meaning you spoke up about discrimination at work and they're retaliating against you or something like that, or that you don't have a contractual protection, whether that's a collective bargaining agreement that provides progressive discipline or an employment contract that says, I don't work in December every year, and the employer decides to fire you because you weren't there on December 15th. That would be a breach of contract. So but all of these issues about vacation and personal leave, the bottom line is in the job protected 12-week period, the employee is protected for leave that's covered. Once they get out of that 12-week period, even if they're not fully recovered from the condition, it's up to the employer at that point. So some people will have employers that say, take all the time you need. Others will say, I have to let you go because I need to fill that position permanently.
And I brought up that point just to be sort of clear about the parts of existing law that we would be changing here and which we wouldn't be changing.
Yeah. I think the big takeaway is this law just provides wage replacement that you can use during that 12-week period. And this bill would not extend that 12-week period except for the safe leave instance that I discussed earlier.
And Damien, are you able to go until noon if we move our 11:40?
I am.
Great, thanks.
Yep.
We're gonna do that.
Okay.
Sorry.
That's fine. Eligibility. An individual has to be an employee or an enrolled self-employed individual who earned wages. And again, this might change during 2 of the last 4 calendar quarters, or earned self-employment income that they paid contributions on during 2 of the last 4 calendar quarters, or both. One thing I want to note is you'll notice that this doesn't require that the individual has earned wages or paid self-employment income contributions in the current calendar quarter or the most recent one. That's an important caveat with this. Employee doesn't mean currently employed. For purposes of this law, it means that you've been employed during 2 out of the last 4 calendar quarters. Just something I want to highlight, something you could change, but it's an important caveat. So you're not necessarily currently employed. So someone who's a seasonal employee and then gets sick or injured after their seasonal job finishes before they've found a job for say they work at a ski resort in the winter and they haven't found a job for the summer yet. If they get injured in that intervening period, provided they've paid enough contributions in the past year, they're eligible for the leave. They just don't have job protection because there's no job to go back to.
And so if my employer had opted out of the state program because they were going to have a comparable program, they would also have to do the same?
So that is not explicitly addressed in the bill. And I would suggest that you likely want to clarify that. Yeah. If that's your intent, I would make that clear. And if that's not your intent, I would also make that clear. Yeah. So Yeah.
it clear.
So let's mark that as something we want to make clear in one direction or the other.
Okay, and then the individual has to be, whoa, I'm sorry about that. Individual has to be unable to work because they have a serious health condition, caring for a family member, they're pregnant, they're recovering from childbirth or miscarriage, caring for a new child during the first year following birth, adoption, or placement for foster care, taking safe leave or taking bereavement leave. And as I mentioned, qualifying exigency is the one thing that's missing from this list, but is included in the definitions. And that's covered under FMLA. It's not covered under our state unpaid leave law currently. So larger employers in Vermont are required to provide leave related to the deployment of a family member. And that can be everything from arranging for childcare or making financial arrangements, housing arrangements, to going to military ceremonies for the departure or return of a family member. The other thing the federal law covers, which is sort of lumped in under family leave in this case, caring for an injured family member, is it provides leave when your family member comes home wounded from their service overseas. And the federal law provides 26 weeks of leave for that, unpaid. This would provide 12 weeks of payment that you could use under the family leave, but no extended leave. That would again be covered by the federal law if you work for one of the few employers in Vermont that's covered by it. And then the last is the director has to determine that you're not disqualified. So they would be checking to make sure you're not receiving unemployment, workers' comp, or wages or other payment. This is the most likely instance where they would later find out that you were overpaid. So if you were taking intermittent leave and you coded your time card for sick leave on a day that you also got paid leave benefits, they could potentially recoup the paid leave benefits at a later date. So applications, you can apply for the benefits, like I said, within 60 days. You have to, the extent possible, provide documentation of the need for the leave. And the director would specify acceptable forms of documentation on the application so that people have examples of what they can provide. It's really important to note that the documentation is going to vary depending on the type of leave. So if it's military exigency, it's probably a copy of your family member's orders or other information. If it's parental leave, it can be the adoption paperwork. It can be just a notice that you had a birth or that you have a scheduled C-section. If it's medical leave, it may have to provide additional information regarding the actual need for the leave, because the individual processing the application, much like the HR person at your employer, is not going to know enough to be able to determine whether you need 6 weeks of leave to care for a family member. That's going to be something that the healthcare professional is going to provide you with. They're going to say, you know, their condition, without providing too many details, requires someone there to help them with cooking, cleaning, bathing, et cetera. And so they need a family member there full time. Does that make sense? Okay.
And safely?
Safe leave, the documentation types are laid out. Again, it doesn't have to provide the specifics of the incident, but it can be everything from a statement from a mental health counselor or a member of clergy or a healthcare professional that treated you to a police report. Importantly, it's the employee's option what they provide, not the employer's option. So that prevents instances where someone says, well, I need a police report, and the employee doesn't want to file a police report because it's their intimate partner that is the alleged perpetrator. with all of it, any information on there has to be kept confidential. And the employee doesn't necessarily have to provide all of the details, just that there's leave needed for safe leave to relocate, to get health treatment, to recover from injuries. So it could be a healthcare provider saying the individual sustained injuries that are going to require 3 weeks of recuperation, or something like that. And so it's currently doctors are doing this for medical leaves, where they're walking on that fine thin line between what HIPAA prohibits them from doing and what FMLA requires them to do. And so they provide general information saying, the individual has a medical condition that's going to require them to be in the hospital for 3 weeks of treatment, or they're recovering from a severe accident. We expect them to be in intensive care for 2 weeks and then require rehabilitation for 3 months after that, something like that. And that, they don't have to go into the specifics of what the exact condition is that the employee is dealing with, or how they suffered the injuries and so forth. So.
Yeah.
In terms of safe leave, does it include, for the people who provide paperwork, does it include a mental health practitioner?
It does. Let me pull that up. I zipped by that a little bit earlier. So for safe leave, we allow documentation from a court or a law enforcement or other government agency, a domestic violence, sexual assault, or stalking assistance program, a legal, clerical, medical, or other professional from whom the employee or the employee's family member received counseling or other assistance, self-certification of the employee or the employee's family member of their status as a victim, signed under penalty of perjury on a standard form adopted for that purpose by a federal or state government entity or a nonprofit organization that provides support services to victims. All right.
Very clear, thank you.
All right. Other questions? Okay. Like I said, it's 5 days to review the document. And then an additional 15 days if the division determines that it needs additional documentation. And then you have up to 60 days before and 60 days after to file it, but benefits don't start until that 2-week period around the start of the leave, or if you file after the leave starts within 2 weeks after the approval of the application. Questions? Okay. Benefits are paid bi-weekly. And they start within 14 days after the approval or the leave begins. Benefits are not assignable, except, like I said, for child support, unpaid taxes, and to recover overpaid benefits.
Benefits are benefits paid back to the original?
So with child support or?
No, just after benefits are approved, are the payments, is there a back payment to sort of the beginning of the?
Yeah, you backdate the payments. So your first check could be quite large.
Thank you for helping me with that
Yes.
sentence that I could.
That's okay. Thanks for clarifying. But yeah, if you file 60 days after the leave starts, you could be getting, 8 weeks of benefit payments or more in your first payment. So. So let's see. It's also worth noting with child support. So if there's outstanding child support, it's automatic withholding. If you regularly owe child support, but you don't have any outstanding amounts, you can still ask the division to withhold it and forward that to the child support agency or wherever it needs to go. And then you have to be notified when you file for benefits that they may be subject to income tax and the benefits may be subject to withholding, and then all withholding requirements under state and federal law apply. To give you a really quick rundown on the income tax, the basic gist is that your own injury is
No,
likely not
just-
subject.
Abby has like a whole memo, so like let's wait until Abby comes tomorrow. I don't want her to not get to really claim that memo after she puts all that work in.
I won't steal her thunder. So, and she can do a better job explaining than I can. So let's be honest. Elective coverage, this just governs the election by the self-employed individual. Like I said, it's a 3-year period with 1-year periods thereafter. Once you get through the 3-year period, it's an annual, you basically stay opted in until you opt out. And you, just like your annual enrollment period for employer-provided health benefits, you have an annual opt-out period as a self-employed individual. The only exception to that is if you become an employee, so you quit your self-employment and take a full-time job somewhere else, or you stop working in Vermont and move across the country to Arizona or New Mexico, something like that. And so in those cases, you basically provide 30 days notice to the division and they discontinue your enrollment in the program. Questions? The employer private plan options. So basically an employer can meet their requirements for approval here by providing self-insurance or obtaining an insurance policy. So it could be something like through the Hartford. It could be like what the state does for health benefits, where the state self-insures and then has a benefits administrator that administers the program. The director has to ensure that a private plan provides leave for periods that are equal to or more generous than the requirements of the law, provides coverage for all employees who would be covered under the state plan, costs employees the same or less than the state plan, than their portion of the contribution under the state plan too. So it's that right now 0.275%. Provides coverage for all forms of leave for which benefits may be paid, provides wage replacement in an amount that is equal to or greater than the wage replacement provided under the state plan, and imposes no additional restrictions or conditions on the use of leave. So basically, state plan or better. And you can do that through self-insurance or a private insurance plan, but that would get you out of participating. Questions on that? Okay. So typically, an employer wanting to take advantage of that would enroll on October 15th or apply on October 15th of the year. The state has 45 days to review the application. Approval comes December 1 with a notice to the employer and the Department of Taxes that beginning January 1, they no longer have to withhold contributions. And then same thing if you want to quit your private plan and enroll in the state plan, you have to notify the state on or before November 1st of the prior year. So it's this same sort of fall enrollment and disenrollment period. And then the director can terminate the approval of a private plan if the plan fails to pay benefits in a timely manner or in a manner that's consistent with the plan's terms, misuses the private plan funds, fails to submit required reports, or fails to comply with any applicable provisions of the law or with rules adopted by the director. And it's important to note that that's terminating the approval. The state does not have the authority to terminate the plan that the employer has. That's covered under ERISA, which is federal law. So this would just basically be saying you have to meet your requirements under state law by enrolling in the state's plan. So does that make sense to everyone?
Yep.
Yep.
Yeah.
Question questionable solvency is not among the list.
No. So it does require that you provide self-insurance in a manner that's approved by the director. It is silent as to whether you have to back up that self-insurance with a bond or some other provision like that. Some states require that, some states don't. So that's a policy question.
I think.
Yep.
Just under ERISA, that's a problem for states to review the solvency issue.
Right. And so what this language, the general committee had me work with the folks from DFR who had expressed concerns about some of the original language and places where it may cross into ERISA territory. And so the language has been trimmed down to be just a thumbs up or a thumbs down on the plan.
Representative Brannigan.
Do we know roughly how many employees are covered by these kinds of private plans that the employer would want to continue?
I do not know that. I think these plans are fairly new in Vermont, but I don't know. I know in other states that have this provision, there are some employers that have opted out.
And we have some national witnesses that are scheduled to come in, and that would be a great question for them.
Okay.
Yeah, they would probably know far more than I do about what the experience is nationally with these.
And for the whole committee, the Department of Labor in the last few years has really bulked up their documentation around these kinds of programs. And so there's a lot more resources on the Department, federal, not the state.
US Department of Labor.
US Department of Labor has a whole lot of resources on paid leave programs available now to really dig into, including, modeling strategies and best practices and all kinds of things. Anyone wants to spend some time in there.
And all the free time you guys have. So a termination of the approval is appealable, just like any other adverse decision. And then each employee covered, like I said, on the date the plan is terminated, is for purposes of determining eligibility, treated as if the employee had paid contributions for the entire time that they were employed and covered by this private plan. Some things that this doesn't address are issues like, what if the employer just goes out of business and they don't terminate their plan? And then there are other questions about employees who, I think as I read it now, if you work seasonally for an employer with a private plan, when you stopped working for that employer, you would be not covered by the state plan. But again, you could make that crystal clear, or you could provide otherwise if that was your intent. Just worth noting.
Thank you.
The appeals, I don't think I need to go into this. We kind of covered all of the key points during the previous walkthrough. And then the only thing I would note is just that the decisions and any findings made in an appeal they can't be used in another proceeding. So for example, if you've got a court case with your employer about whether you were entitled to job protection and you had argued with the state over your benefits and the state had ended up approving you, you can't use that approval against your employer in the argument over job protection, or vice versa. Your employer can't use the fact that you were denied benefits in that argument against you, because they're slightly different standards. And so similar to unemployment insurance, where this language came from, the goal is to prevent people from saying, well, that administrative finding that was limited to this insurance program is going to provide some sort of precedential value in this other proceeding that I have going on. I've covered the fraud provisions. I don't think I need to go into more depth with those unless you have questions. Are there any questions on the fraud or repayment? Okay, I'll move past those. Rulemaking, it's for the Commissioner of Taxes on the tax withholding, and then the Director of the Division for everything else. Confidentiality, as I mentioned, anything that would reveal an employer or individual's identity is required to be kept confidential. This does allow for aggregated information to be made public. So we had, 200 claims for parental leave and 400 claims for own medical leave and so forth. But they can't provide information that would identify an individual or employer. Disqualifications, I already discussed. The key piece is its temporary total disability benefits, or temporary partial disability benefits that are related to the serious health condition you're seeking leave benefits for. The reason for this distinction is the idea is that if you're on temporary total disability, you're unable to work anyway, and you're already receiving workers' comp benefits for that. If you're on temporary partial, you may be working in a limited capacity. And as long as it's not the same health condition, you could receive these benefits on the side. And the idea there is that you don't deny someone the workers' comp gives you medical care in addition to wage replacement. And the idea is to prevent someone who is recovering from another workplace injury and then has to take a medical leave related to something else to lose their medical treatment benefits and other things they're getting for that first injury. Unemployment compensation is self-explanatory, and then wages and payment for accrued paid leave, I think, are self-explanatory unless you have questions. Okay, retaliation and interference. As I mentioned, we've used the retaliation provision from our anti-discrimination statutes, which is basically retaliation for exercising your rights or for the employer's belief that you're about to exercise your rights. And then, or for participating in an investigation of a violation. And then the shall not interfere with, restrain, or otherwise prevent an employee from exercising or attempting to exercise rights. Just goes to potential coercion to prevent an employee from taking paid leave.
I have
Yeah.
a question on this. I'm not clear on what at will means. So if I'm hired for something and the employer makes it clear, says, you're hired at will, which means I can fire you anytime I want without cause.
Yep.
So if they say, okay, I want to take I've got a serious illness, I want to take my benefit. I assume that the employer can't say, okay, but you're an at-will employee, you're fired.
Yeah.
And,
So-
or when they come back from their leave, can they say, okay, you're an at-will employee, now you're fired?
So, two separate answers here. The bottom line with at will is limited by contracts and public policy. So as public policy, we've set laws that you can't fire someone or discriminate against them because of a number of protected classes, race, national origin, religion, et cetera. And then you also, the other public policy provisions are all of these essentially whistleblower protections that we have, which are these anti-retaliation provisions, where if you provide the Department of Labor with notice that you haven't gotten a paycheck in 4 weeks, your employer cannot fire you for contacting the Department of Labor. Same thing if the employer thinks or finds out that you've either filed a complaint of discrimination or that they think you're about to do that, they can't fire you for that. So those are the limitations on at will. So at will is always qualified by whatever the other applicable laws are. So it's the best way to think about it is that's the common court law. Mm-hmm. And then when we write statutes, we trim that court law down. So we narrow when it applies. So when you request the leave, they definitely can't fire you because that would be almost de facto retaliation for taking the leave unless they can somehow show that it's related to a legitimate business reason, like, you know, you've had horrible performance and it's documented and you got your third strike or whatever it is under their policy for discipline. And that just happens to come the day after, you know, you requested your leave. So it's a completely unrelated reason. When you come back, it's the same thing. There may be a presumption if they fire you right away, just based on the closeness and time, that on its face, that appears to be retaliatory. And then they have to show a legitimate business reason for the firing. So say you came back to work and on the day you came back, you assaulted your boss. That could be a good reason to fire you. That's not related to the leave. But in each of these cases, it gets complicated. There's a burden shifting piece where the person alleging discrimination has to show that on its face, there's a relationship between they did something that's protected by law, they got fired or otherwise discriminated against because of that. And then the employer gets a chance to show that, no, there was a legitimate business reason. And then if the employer makes that showing, the employee has one last chance to show that that legitimate reason was actually just a pretext. And the court takes all of those factors into consideration when it determines discrimination.
And it's a court that adjudicates that.
Yeah, you've got a judge. You may have a jury, depending on the case. So there's a lot of fact finding and a lot of evidence in court that's going to come out. And the bar is pretty high to show, to make these showings, especially if your employer has, for example, a documented disciplinary process or there was some egregious act that occurred that led to the firing. The employee is going to have a very high bar to meet to show that it was actually pretextual.
Okay, thank you.
Page 35.
Yes. So are there other questions about discharge or discrimination? Okay. Notice, like I said, this is standard notice language, except that we're also requiring written notice to new employees.
I love that that's part of that's a new cycle that's being floated around.
It's starting to be brought in. The employer obligations and employee rights, this is just basically the best way to sum this up without going into it again is that as an employee, you have a right to the better of your employment agreement or collective bargaining agreement or employer policy or the law. And as an employer, you have to abide by your contractual agreements unless the law sets a new higher bar, in which case you have to follow the law. So that's basically what this is saying. And then it goes into job protection. I mentioned with bereavement leave that it's the same protections as under family and medical leave in Vermont and safe leave. So you have to be offered the same or a comparable job, same level of compensation and benefits and seniority, and any other terms or conditions of employment as on the day the leave began. Notice it's not the same job. Your employer may have had to fill that job and may have to shift you laterally within the organization. And then it doesn't apply if you had given notice or been given notice, including a limited term contract before your leave began, or if your employer can demonstrate by clear and convincing evidence that your job would have been terminated or you would have been laid off for reasons unrelated to the leave, or that they would have suffered a severe economic hardship if they couldn't have replaced you with a permanent employee because of the unique nature of your job.
Yeah, Carolyn.
I don't know if this would really happen or not, but What would happen if an employer tried to put a person who worked from 8 to 5 onto the night shift? Same job, but doing it at night. Say it's packing boxes. Instead of during the day, it's at night, but it's the same job, maybe a little more pay, as night jobs typically are.
So,
After they came back from family leave?
yeah, I think the question, or would be a couple different questions that would have to be settled there. One, is it the same or comparable terms, conditions, pay, benefits, position? The other is that move retaliatory? So if it's like, if you shift someone to a less desirable shift because they took family leave, you may have an allegation that it was retaliatory. It's going to go to if it gets into a dispute, it'll go to a fact finder if you don't settle the dispute. So the employer is going to have to weigh sort of the options of, is this potentially a retaliatory move or could it be construed that way? The employer may have good intentions. That's where they have an opening right now. But there are questions like that come up. They come up under the existing law. It's hard to give you a bright line answer because it's going to depend on the job. And, you said maybe there's more pay. So maybe they got a raise, but the only position they had was on the night shift. And a lot of times with these cases, there are shades of gray, and if it does go to court, judges are making calls on very sort of like narrow facts that apply only to that case because of the unique circumstances around the work conditions there and the pay and other benefits that may be offered. So I wish I could give you a clear answer, but.
Oh, okay, thank you.
Amy, is there a seniority piece in here?
Yeah, you have to retain seniority, the same as, so it says, same level of compensation, employment benefits, seniority, or any other term or condition of the employment existing on the day the leave began. So you don't lose seniority as the result of leave. You're not required to gain it, although you may have a collective bargaining agreement that provides that your seniority continues while you're on leave. So. Okay. And then we get into the definitions. As I mentioned, you might want to revisit the average weekly earnings depending on how you decide to determine benefits. But we can leave that for now, pending a review. Right now, as I mentioned, it's the 2 highest earning quarters in the last 4. Bereavement leave, as I mentioned, it includes leave due to the death of the individual's family member within not more than 1 year after the death. So this allows for a delayed memorial service or something like that. But then leave related to the administration or settlement of the family member's estate can be taken more than 1 year after the death. And that reflects that oftentimes family court is a very slow and lengthy process.
That definition of family member consistent with the broader, more
Yes.
inclusive definition?
That the broader, more inclusive definition of family member is applied throughout. So, domestic partner in here, I'll highlight that to revisit, just like above. Employee, again, you may want to revisit this. Right now, it's defined as an individual who receives payments for services performed for an employer from which the employer is required to withhold Vermont income tax pursuant to the wage withholding statute. So that would exclude an independent contractor who's paid on a 1099.
And that person could opt into the self-employment.
Yes, exactly. Family and medical leave, as I mentioned, this includes qualifying exigency arising out of active duty service in the U.S. Armed Forces, or an impending call or order to active duty in the U.S. Armed Forces. I want to make clear that U.S. Armed Forces is defined to include the state National Guard. So the National Guard, when it's on state duty status, it's a dual state federal body. When they're on state duty status, under federal law, they're not considered part of the U.S. Armed Forces. For our purposes here and the purposes of saving words, we're defining any state active duty as service in the U.S. Armed Forces, just to capture that. So if you're called up because there's another natural disaster in Vermont, you're covered for that qualifying exigency if you need to, if your family needs to take a couple days to arrange childcare because that parent is the primary childcare provider.
Yeah. Oh, actually, Carl's gonna go first.
So it covers any state National Guard service, whether in-state or out-of-state, if it's a deployment, if it's.
Or if you're a Vermonter who serves in the New York National Guard or the Massachusetts National Guard, you're covered.
Thank you.
So, yeah, it's recognizing that National Guard members don't have a choice about when they're called up. So.
And why is it what's the difference between this definition of employee and the one on section 3?
So the definition
Or employer, I'm sorry.
Yeah, the definition of employer here means any person with one or more employees. It's identical to the one
Maybe it's
in
employee.
section 3. Employee is different. And the reason there's difference is because you can be an employee that your employer is required to withhold contributions for before you're an employee who's entitled to take leave or receive wage replacement. So employee under section 3 is really closer to the definition of, or part of the definition of a qualified individual, which is someone who's had contributions paid in for long enough that they're eligible. And then it also includes individuals who've just moved to the state, but have been with their employer long enough that there's an entitlement to leave.
Okay.
So, yeah. Getting to family member, as I mentioned, that's the broader definition. Are there other questions about that? Okay. Healthcare provider, same broad definition that we went over in section 3. Highest earning quarters, again, this may change depending on how you want to track or determine someone's wage replacement. And loco parentis, so this is based off of the federal definition, simplified because of how complicated that definition was. So it's a relationship in which an individual has day-to-day responsibilities to care for and financially support a child. Let's see. Qualified individual covers both self-employed individuals who opt in and employees who have had enough contributions paid in.
And the owner of a small business could, depending on how their business is structured, either be an employee of that business or be a self-employed person.
That's correct. Yep.
But they would be covered. They would,
Yes.
might be covered differently depending on how their business structure.
Exactly.
But the nanny whose the family hires
An
them,
employee.
if they file is it
Yeah, if they're-
H2, there's some form.
Yeah, so if they're paying them if they're reporting her income on a W-2, she's an employee. If they're reporting her income on a 1099 because she's an independent contractor, she'd have to enroll as a self-employed individual.
And we won't get into whether or not they should,
They're-
we're not
I'm
going to.
avoiding the employee versus independent contractor discussion. So,
Representative Maslin.
When we're done online, I have a story to tell about a neighbor constituent who drowned. And there was a question on whether he was on active duty for the Army or for the Guard. And it was an interesting thing, but it really doesn't need to be part of the discussion.
Okay,
No, but it was, someone
seems like you're telling the story.
intervened above and beyond to get things done right.
Good.
Okay. The safe leave definition we've gone over, this is identical to what was in section 3. Self-employed individual, it is a sole proprietor or partner owner of an unincorporated business, the sole member of an LLC, or the sole shareholder of a corporation. Notice it can be any type of corporation, so we had questions about B Corps and S Corps and just sole shareholder of a corporation. Importantly, if you're part of a partnership that runs an LLC, or if you're part of a multi-shareholder corporation, you're going to have to pay yourself as an employee. So that's something that is a policy decision, and you could go dig into that deeper, but that's where the general committee drew the line for this. And it doesn't matter if you have employees or not. You could have employees, you could be just yourself. So, questions? Okay. Self-employment income has the same meaning as in 26 USC 1402. So basically, if it's self-employment income for purposes of your federal income taxes and Vermont income taxes, it is self-employment income for purposes of the program. Same thing with wages. We've defined that same definition of wages as is employed under the Internal Revenue Code and then used by Vermont. Serious health condition we discussed. That is identical to what was in section 3. Sexual assault and stalking, we're using the domestic relations definitions. U.S. Armed Forces includes the Army, Navy, Air Force, Marine Corps, Space Force, and Coast Guard, and any reserve component of those, and the National Guard of any state. So I know Space Force always gets giggles, but
I have a friend who works for Space Force and I like live to tease them about it, so I'm actually gonna send a picture of the statute.
it's all right. I have to admit, I'm a fan of the Space Force, but that's because I like space and rockets, so it's cool.
They're the one watching out.
Going on.
They're
so,
watching out for those balloons. It's good.
Anyway.
Go back, thank you, sorry for.
But yeah, so this is up to date. If we do add any additional branches of the US military at some point, we'll have to add additional components. This does not cover NOAA or the Public Health Service, which are both found within US Title 10 to some extent. So they're part of the uniformed services. They're not considered part of the armed forces. So.
Thanks.
And then tax information here.
Can I actually ask,
Yep.
so NOAA,
Yep, National Oceanographic.
yes, do they deploy?
No,
Great.
I don't know why they've ever been included. Why the uniformed services, the public health service too, is covered under the uniformed services. So
They also
they're
don't.
entitled to, exactly.
That's why they're not on this list.
Yeah, I'm not sure why they were grouped together in the history. I've gotten that question before.
I don't, that part doesn't,
So,
bother me. I just want to make sure
yeah.
that we're covering all the
Yeah.
deploying people.
They don't get sent off on active duty. You're either an employee or you're not.
Okay, thanks.
So you don't have a NOAA reserve that I know of. So I'm trying to contemplate that job. So, this just allows the Commissioner of Taxes to provide tax return information as necessary to the Division of Family and Medical Leave, primarily for income documentation. The Commissioner of Taxes had requested, and it was added in House General, that there be a reciprocal information, and that's covered in an earlier section. Rule adoption, as I mentioned, is by April 1, 2025. This gives hopefully enough time to stand up the departments and adopt rules. Rule adoption takes about 6 months from filing to the finish, but that doesn't include the time ahead of time to actually develop the rule before you file the proposed rule. So this gives you 21 months from the effective date, which should hopefully give you enough time to develop rules after hiring staff.
Okay, and we're gonna hear from the commissioner on Friday, I think. And I think with that, we're actually gonna stop and we're gonna pick time up with you, Damien, after the floor.
Today?
Yeah.
Oh, I am scheduled right after the floor downstairs, but I can come up here as soon as I'm done with that.
Okay, well, you two can